Welcome to the new and ongoing challenges with child support income withholding orders portion of today's conference. My name is Michael Pochia, and I am the Executive Director for Enforcement Operations for the New York City's Human Resources Administration Office of Child Support Services. During this session, I hope to provide some practical guidance and information regarding all those what I always wanted to know questions regarding the mechanisms and procedure of the IWO and employer responsibilities in implementing them. But before we begin, it is important to acknowledge the importance of our partnership here today. IWOs play an incredibly important role in ensuring that nearly 1 million of our state's children have the financial support from both parents. What we'll be talking about today, and the topics below that you're seeing were based on, in some part, the questions that employers and payroll specialists were asking the state call center. And so what we're going to talk about today is the importance of the income withholding order, how to report, understanding what the wage and health benefits report is, commonly known as the Weber, the employer's responsibilities for IWOs, certain changes, how to deal with lump sum payments, and how to treat independent contractors. Before we dive into the substance, I just want to throw out there something I try to remind myself every day. All of us, every day, we deal with paperwork, we deal with charts, graphs, statistics, calculations, phone calls, emails. We designate individuals as custodial parents, non-custodial parents, employees, independent contractors. We sometimes forget that there are real people, real families impacted by what we do and what we fail to do. Each of us together affect the social and economic well-being of not only the children involved, but the parents that are part of this process. And we must strive very hard to do things right. So to begin, and there are numerous employers in the audience today, payroll services, other individuals from different organizations participating today. We'll start with the very basics here. And that is that third-party agents, meaning payroll services, handling the duties have the same responsibilities that an employer would. And the employers are responsible for ensuring that their agents meet the reporting responsibilities that we're going to discuss throughout this presentation. This is all under under federal and state law. And these responsibilities include, starting with new hire reporting. Very important to the process. Employers must report all newly hired and rehired employees within 20 days of the hire date. This information is maintained in the National Directory of New Hires and in New York State in the quarterly wage reporting system. What happens here is that our system, our state child support system, the automated state support enforcement tracking system, referred to as assets, does matches to these two databases. And as there are hits, that's how most of our IWOs are generated. This process is automated, and this reporting and doing it correctly and doing it on time helps speed up the process in collecting and distributing child support, and helps make the process go much more smoothly. There are penalties involved if employers don't follow and don't report within those 20 days, but we're not even going to worry about that because I'm sure all the employers will have, or after this presentation will meet that 20-day mandate and help make this process go more smoothly. What needs to be reported? And this is information that many of you are doing already. If there are new employers, if there's new payroll services, the data, very, very simple. We need the name and address, social security number of the employee. It helps make sure that there are no mistaken identities involved in sending the wrong IWO to the wrong person. The hire date, we need to know the name, your name, the employer's name and address, as well as the FEIN number. Also, you're reporting the dependent health insurance benefits if available. All very important information, all which makes this automated process go much more smoothly and efficiently. How to report? Well, one thing we learned, I guess, during the COVID time is that most of us can work from home, and we are becoming more and more of a paperless society much more quickly. And there are different methods on how you report this information, but it could be done online and electronically, the most efficient, effective way to do this. You could do it by fax, you could do it by mail, there's even contact information and a phone number, all different methods of doing it. However, again, I always want to emphasize now and throughout this presentation that doing things electronically works best for us, works best for you, works best for everybody involved, as a matter of fact. And again, I'm going to encourage throughout this presentation, the push that your organizations, your payrolls, your employers, your human resources administrations all try to follow and work towards electronic filings.
Good morning, everyone. My name is Angela Baracco-Levine, and I will be introducing the polls for the employer conference today. This is important to note. To receive APA credit, you must respond to each poll during today's conference. The poll should appear on your screen. If, for whatever reason, you cannot view the poll, please let us know in the chat, and we will work with you. Poll number 1. Employers must report all newly hired or rehired employees within 20 calendar days from the hire date. True or false? That statement is true. Back to the presentation.
The Weber. Your employer's payroll services may also receive a wage health benefit report, in which we are seeking earnings and benefits information for your personnel. This document is separate from the IWO, but just as important. New York State doesn't generate the Webers in all cases like it used to, but its use on the child support system for collection information is critical. New York City specifically sends out these forms to employers and independent contractors, especially during when we're trying to find information on modifications, on COLA, on independent contractors. And we could use that information, again, to make sure that the orders we have are in line what the employee can pay and should be paying. Now, turning to the income withholding order, the 4 pages of huge impact, our best friend. The income withholding order is going to be obviously a major part of my presentation, and we're going to break down those 4 pages and the critical information contained in the income withholding order. The official title of the form is the income withholding for support. the IWO is considered an order when it comes from a 4D child support program or when it comes from the court. It's considered a notice to you if it comes from an attorney, a tribal legal representative, a private collection agency, or a non-custodial parent himself or the custodial parent himself, herself, could send it. If it's a notice, and this is distinguishing between the order, if it's a notice, the notice has to have the order attached with it, as opposed to when it comes from child support or from the court, when the IWO itself is an order without more. All payments must go through the support distribution center. That information is on the IWO, and we're going to talk about that briefly very soon in the presentation and its importance. Maybe I'll mention it right now. Notices that do not have direct payments to the SDU, the Support Distribution Center, should be returned to the center, to the sender. It's not a valid IWO if it's not made payable to the Support Distribution Unit. Critical points to remember, to keep in mind during the IWO. First and most importantly, there is no stigma to the IWO. It's not an indication that the employee did anything wrong at all or is unwilling to pay. It's an automatic process that the IWO goes out to the employer once identified. Now, historically, and for those of you that maybe have been involved in the payroll process for a long time, prior to 1996, we had something in New York called a default order. That was where if the non-custodial parent wasn't paying on time, then the IWO would go out. That's not the case anymore. It's automatic. It's done at the beginning of the case. It's for the benefit of the non-custodial parent and custodial parent that the IWO goes out as quickly as possible. Employers cannot charge a fee for the income withholding order. Employers must comply with the income withholding order and may not discriminate against employees in any way because of child support deductions. It is actually a crime in New York, both criminal and civil penalties, to lay off an employee, to discipline an employee, or refuse to hire an employee because of the existence of the IWO. An employee can't even go to you, the payroll, and say, I don't want this IWO, I want to pay myself. It's mandatory that the employer follow the IWO. The only circumstances in which a non-custodial parent could self-pay when they have an employer is if they make a good cause exception to the court, or they work out a deal at the beginning of the case with the custodial parent. Other than that, the IWO must be followed, even if the employee comes to you and says, I'm okay, I'll pay on my own. You must comply with that order. Having the order in place benefits the non-custodial parent because it keeps that individual out of certain of our administrative enforcement processes if they become behind in paying their child support. They may not necessarily go into our Department of Motor Vehicle, our license suspension process. Their bank account might not be restrained of having the IWO in place. So this part of the process, very important to follow what the IWO says and to implement it as soon as possible. Determining what should be withheld. Back in the day, my tax professor said, everything is income unless somebody tells you otherwise. And that's not far off to the way we operate here in New York State. There is no federal definition of income. Our definition in New York State is derived from and contained in the Civil Practice Laws and Rules, the CPLR. And income, my goodness, is just about everything. It's benefits, it's salary, it's periodic and lump sum payments, it's wages, it's workers' compensation, disability benefits, pensions, retirements, Social Security. All of those things are considered income in New York. Perhaps the two biggest exceptions of what we consider income is cash assistance and supplemental security income. And in theory, an employee should never be receiving these if they are working. But except for those two bullet points, cash assistance and SSI benefits, most of everything else, most of what you see in front of you here is income and has to be looked at for IWO purposes and income executions. With IWOs, it's not just the who, what, or where. It's the who, what happens, when, how much, how often, how to pay. And we're going to discuss each of these different points, topics during the presentation. We're going to look at the type and source of the IWO, confirming employer and employee information, the importance of the employer notifying us if the employee is terminated or maybe never worked for you, checking the date that the IWO was issued, reviewing the order information and amounts to withhold, checking the Consumer Credit Protection Act, which we'll talk about during this presentation. Very important because there's an obligation amount in the court order. There's an amount that has to be paid on the IWO, but it's also important that we don't leave the non-custodial parent without any money to live, to take care of their basic needs. All of this is contemplated in the IWO and in the instructions and procedure. All of this is going to be made hopefully clear during this presentation. And of course, remitting payments, how to do that, and there are multiple ways to do this. So to begin here with the IWO, we want to check the type and source of the IWO. And right at the top of the IWO, there are those four boxes. The IWO you might be receiving could be an income withholding order, presumably on a new child support case, a new order. You could be receiving an amended order. Maybe the non-custodial parent no longer has to pay arrears, for instance. There might be a lump sum involved. This might be a termination IWO sent to you where perhaps the children in the case are emancipated. The non-custodial parent doesn't owe child support anymore, and we want to stop the collection of that income withholding order. The non-custodial parent met all their responsibilities. Two, you want to check the source of the IWO. Again, as I said, it could come from child support enforcement. It could come from the court. That would be an order. It could come from an attorney. It could come from a private individual, making it a notice where you receive not only the IWO, but the underlying court order. The IWO must be regular on its face, right? Regular on its face, which basically means that any reasonable person looking at it would think it's valid. Certain things to look at to determine, I guess, more specifically, to see if that IWO is regular. Well, you want to check to make sure that it's payable to the SDU, a disbursement unit. You want to make sure that the underlying order is attached if it's a notice. You want to make sure that the order is in United States dollars. You want to make sure that there's no text that was changed or anything else altered to the document. If there is, you have to notify us immediately, send it back. It's not to be honored if any of those things if any of those issues are present, making it, we'll say, non-regular. You want to confirm the key details of the IWO, the employer's name, the employer's address. Again, these steps, very important. We want to make sure that the IWO is being sent to the right location. When employers sometimes send new hire information to the Department of Labor, you're sending that information to an address, not necessarily where your payroll is, where you want the IWO processed. Having that information, that key detail, we can then review it. We can make sure that the IWO goes to the right place, not only in this case, perhaps, but all cases where you are the employer for different non-custodial parents, because we could check our records. We want you to check the employee's information, the employee's social security number and date of birth. This helps stop any mistaken identity cases, that might happen. While it's important to garnish the employee correctly, the last thing we want to do is garnish somebody's salary that should not be garnished. And having that information, having us being able to check that, again, critical to making sure everything goes smoothly, everything goes effectively. Termination and past employees, again, important. While a lot of our information on employers is automated, there are times where a third party, maybe it could be the custodial parent, maybe it's somebody else telling us the non-custodial parent works at XYZ Corporation. We will build a record, an employment record based on an information, and the IWO will go out. We don't know at this point if that non-custodial parent employee works for your organization under these circumstances. So it's critical you let us know, and I think it's page 4 of that IWO, that this person doesn't work for you any longer or never worked for you. That helps us clear up our records, and that helps stop you from receiving those follow-up non-compliance notices that we haven't heard from you regarding the IWO. It stops my staff from perhaps following up and calling your payroll because we haven't heard from you. So again, to make the process go more smoothly, and for you, I guess, not to be bothered as much through correspondence and phone calls, if you let us know this information as soon as possible, it helps. It also helps us if you let us know not only that the employee is, say, terminated or doesn't work for you anymore, but where they are working now, if you know that information. We can act on that information, terminate the information from your employer, stop the notices from going to you, and send the IWO to that new employer that you help us identify. When to start withholding and remitting. The rules are that the employer must withhold no later than the first pay period that occurs 14 days after the date of service of the IWO. And that employer or payroll service must remit payment to the New York State Child Support Processing Center within 7 working days of that pay date. Not withholding or remitting could result in penalties to the employer. Again, we know that all employees and payroll services hearing this presentation today are gonna see what I'm saying here today, have read the IWO, know what they're supposed to be doing. So no, we don't even have to talk about penalties, but they do exist. They do exist, and none of us want penalties. None of us need those penalties. We want to follow these rules because, again, payment going to the non-custodial parent, to the child, at the earliest possible time benefits everyone that's involved. As an example, suppose the date of the IWO is October 31st, 2018. However, the first pay date in your pay cycle is the 2nd. You have 14 days after the first pay period. You're not going to make that first date of the 2nd. It's too early. You can't implement the IWO. You can't finish processing, right? The date of which the 14 days out for that IWO would be the 14th in this case. And you have to begin withholding by the 14th. The next pay cycle for your organization is the 16th. That's fine. That's fine to pay and to meet that next payroll. So where the 2nd was too early, the 16th being the next payroll after the 14 days, that works. So if we understand this chart and understand, and when I said this works, this is practical, this is fine, this is expected. If you can't meet the time between the date of the IWO and the first pay cycle. Determining the amount and frequency of the IWO. You're going to review the order and the amount withhold to determine how much to withhold for the pay cycle for your employee or independent contractor. A child support order from the court will have a frequency to pay. However, the payroll, your payroll, can pay based on their frequency. So when you receive an IWO, it's going to tell you the frequency biweekly. It's going to break it down monthly. It's going to break it down monthly, biweekly, weekly. So you can match your payroll. In this particular example, you see that the current child support is $150 biweekly. $75 for past due child support. That is what we consider, and we'll talk about soon, the add amount. If the non-custodial parent has arrears that are greater than 12 weeks, you'll see the yes box checked, and you'll see amount that's being added to the obligation amount in the court order for past due child support. Again, when you look at this chart, you can meet your payroll's frequency, not the court's. Inherent in this, though, as we go forward, is that this amount, say it's $271.92 biweekly, that amount may be too much for a non-custodial parent to pay based on the amount of money that they make in your organization. Again, we don't want to leave the non-custodial parent, for all better intents and purposes, destitute, without money, despondent, for their own well-being. And there are certain safeguards that exist where the non-custodial parent is not paying more than they could afford. The first thing, and I mentioned this when we talked about the $75 a minute ago, is the add amount. And the add amount is an administrative sum of money that's added to the obligation amount that was set by the court. This amount is put in place when the arrears are greater than 12 weeks. The 12 weeks. That's the procedure behind it. That's the underlying reason why you see it on the order, income withholding order. But it's also the reason why a non-custodial parent may come to your organization and say, my order amount was $150. Why am I paying $75 more? I can't afford it. It is not for the employer or the payroll services to make that determination on whether or not the add amount should be there or shouldn't be there. if the employee comes to you and makes this argument that they can't afford this an amount, that it's unmanageable, right? The employer can form the employee to contact child support, and do what we call and have us do an amount review. It's also sometimes called a hardship review, right? And they could do so, and I included on this slide, they could do so by emailing New York City Child Support at the web address the email address I provided. They could visit customer service at 151 West Broadway in Manhattan, with the caveat that at the time I'm doing this presentation, New York City Child Support is still under certain COVID rules, and our 151 West Broadway live customer service center is not yet fully open. When it will be placed on our website. But for now, the employee should contact us by email or request an ad amount to review through our P.O. Box 830 Canal Street Station. This ad amount, when it's review, we make sure that the extra ad amount doesn't bring the non-custodial parent employee below what's called the self-support reserve in New York State, which currently in 2021 is $17,388. So we're going to review that, and if their income is below the self-support reserve, the ad amount will be taken off. Again, this is part of the administrative enforcement that's done in New York Child Support. It's not for the employer's responsibility, but it would be helpful if the employer has this information and lets employees know if this is an issue, what they can do and how to contact us, and we will work to resolve that what we'll call unmanageable amount to pay. An employer also has to check for CCPA limitations, which is the Consumer Credit Protection Act, which limits the maximum amount of income that could be withheld for child support. These limitations apply to salaries, commissions, severance pay, lump sum payments. CCPA limitations do not apply for compensation for personal service, that are not personal services, which means things like dividends, interest payments, and benefits. What the CCPA is means that when you do your calculations, you will know what your employee's gross income is. What we're looking at here is that it's disposable income of the employee. And disposable income is the amount that's left after the deduction for federal, state, and local taxes, as well as Social Security and Medicaid deductions. Now, in child support, we don't have that information. The employer does. And the employer's responsibility is to make those deductions. Now, I could tell you that if an employer has problems, issues, not sure of this procedure, this is the first time that they've ever heard CCPA limitations, by all means, please contact the customer services helpline for New York State, the customer services for New York City Child Support. My staff will be happy to walk you through it. But these calculations are important to be done correctly. So again, the employee is not left without money to live on. Now, to further complicate the CCPA limitations is, going back, more than prior to 2018, I guess one of the issues with employers that came across my desk is that the percentages to be withheld were sometimes different in different states. And that made calculations very, very difficult. So subsequent to October 29th, 2018, the federal government, I'll say, simplified the approach on how to figure out the percentages for CCPA limitations. And for IWOs dated after 2018, the only issue is whether the non-custodial parent has arrears. And you know they have arrears because the IWO tells you they have arrears. Prior to October 29, 2018, it was not only qualifying arrears, but it was also whether or not that employee had another child support case beyond the one, the IWO that you're now reviewing. We've now simplified this to only two percentages that have to be looked at. I guess because I think this is so important. Again, when you look at IWOs, if the IWO is dated prior to August 29th, 2018, you're going to be using the old rules of which you'll see in a second, 4 different percentages, right? If a new IWO comes in on a new case, and that individual has an IWO from a prior case prior to 2018, you're going to recalculate for both cases. So whereas an old IWO, you were dealing with 4 different percentages to look at, now both IWOs are just going to have the new 2 percentages, which is 50% and 55%. And this chart captures, I think, what I am trying to talk about. I'm going to go to the second, well, we go to the first chart, that makes sense. If the IWO, what we go back prior to 2018, before the percentages in New York changed, there were 4 different possible percentages of disposable income that would apply to this particular non-custodial parent employee. If the employee supported a second family and there were no arrears, there would be, I say no arrears less than 12 weeks, it would be 50% of the disposable income. If they supported a second family and there were arrears more than 12 weeks, that income went up to 55%. If there was only one family and no arrears, the disposable income percentage would be 60%. And finally, if it was a single family and there were arrears, we were up to 65% of the disposable income. Now, for all new orders, all orders after August 29, 2018, two percentages to calculate for income withholding orders, CCPA limitations. It's 50% if there are no arrears. It's 55% if there are arrears over 12 weeks. Again, very important calculations because we don't want to leave the non-custodial parent without money, without salary for their own basic needs. We want to balance the needs of the different individuals in this family. Again, it's not just a custodial parent, non-custodial parent, child, but this is a family, and we want to work with each individual involved to do, as I started the presentation, the right thing for all those involved. After the CCPA limitations, there may not be enough disposable income after that percentage is done for child support garnishment to meet the entire obligation of what the employee has to pay. And when the IWO exceeds the maximum withholding for the employee, the independent contractor, The employers must prioritize the withholdings in this following order: the current support obligation, court-ordered health insurance premiums, past due. Again, very, very important to follow these rules to make sure that the payments are done correctly. The employee can't come to you and say, I want to pay this amount or this amount. It's your responsibility as the employer to follow what's on that income withholding order. It's the same reasoning that tells you that if an employee comes to you and says, I don't have a child support obligation amount, my obligation's terminated, I have a court order. Here, employer, here's the court order. No, the employer has to honor that income withholding order unless told differently by child support with a new income withholding order, amending or terminating the obligation amount. Clearly, the employer can call a New York City Child Support, a New York State Customer Service Helpline if there's a concern. But they can't on their own make that determination just based on what the employee is telling them. When it comes to priority of withholding orders of multiple cases, multiple IWOs, right? Again, there may not be enough money generated from the garnishment of the non-custodial parent employee to cover all that is in the obligation for that non-custodial parent. Employers must withhold payment on each order for current support to the greatest extent possible on a prorated basis. That's the way New York State and most other states operate. Other states may be equal, what they call equal method. We are a prorated state, which means that if you take the two IWOs and the total obligation payment per month of that non-custodial parent is, I don't know, $200. And one obligation amount is $150 for one custodial parent, one is $50. The total amount collected from the non-custodial parent is $100. You can't say, okay, $50 for one non-custodial parent, $50 to the other. That's the way you would do it under the equal method. In a prorated basis, you have to do the total amount of the obligation amount, what each obligation amount that the parent has to pay, and do a percentage of that based on the overall amount to determine how much of that garnishment of the non-custodial parent goes to one parent versus the other. A non-custodial parent employee cannot go to your office and say, you know what, I want you to pay this IWO this month, this IWO next month, or just concentrate on this custodial parent. I like them better. Or in your payroll office, you can't say the same thing where you decide to pay one month, one the other month. You must do these calculations and you must pay each month depending on the obligation amount that non-custodial parent can afford based on the information contained in that income withholding order, based on the information you've deducted from reviewing and deducting based on the CCPA limitations.
This is Angela Baraka-Levine. It's time to take another poll. Poll number 2. Having an order that is paid via IWO can protect employees from certain child support administrative enforcement actions. True or false? Reminder, to receive APA credit, you must respond to each poll. That statement is true. Back to the video.
How to remit these payments from the IWO. Hopefully, if there's anything at all that was positive after this quarantine, again, is that we could all work remotely and be effective, and we become more and more paperless. We can do more and more things remotely over the internet. Here, for remitting payments, I want to stress the importance, the effectiveness of remitting payments through the electronic funds transfer and the expertpay.com website, which are great ways of an employer making the payments without paper, without sending a check. These two methods, methods will result in less errors and costs to the employer. You don't need those coupons. It's quicker and easier. It's more secure way. It's a more secure way of making these payments. There's a one-time setup. You enter the employee data once. You don't have to re-enter it. If you want to know more about these methods, I would strongly encourage you, after hearing the presentation, you call the employer helpline for any other information you might need, to get this done. You can go on the expertpay.com website and take a look of this child support payment platform and how it works, and learn more about the process. Again, doing things automated, doing things electronically is a much more efficient way for us to operate, and is a win-win for both our organization and your organizations. For those of you that don't want to follow the electronic method, or can't follow the electronic method, or are still thinking about the electronic method, you could still remit by check. And one of the most common questions asked by employers is can they submit all in one check? The answer is yes. Yes. You can send the Child Support Processing Center one check. However, you must put the identifying information on that check, or attach that check, each employee, the date of withholding, the case ID for each employee, the amount a payment for each employee, so it's all clear to the processing center to make sure the right money goes to the right case. Another, looking at it again, much easier to do this electronically than to have to do those burdensome checks each month. So again, seriously consider it, and we're here to help you. If there's any questions involved in setting it up, doing it, because it's a win-win for both of us. Employers' responsibilities for lump sums. Probably the most misunderstood garnishment in the world of employer independent contractor collections. Lump sums are included as part of the IWO process. They are used to collect child support. However, that lump sum collection is used is garnished to pay off past due child support. Past due child support, not current child support. So the rules are a little bit different. If, as an employer, independent contractor, your employee is getting a lump sum, there's a mechanism in place, which we'll talk about in a minute, to report that lump sum to the New York State Child Support, and the state child support will tell you, help instruct you, how much of that lump sum to withhold for arrears. So in each case you have a lump sum, you got to consider reaching out. You must consider reaching out to the state to make sure you're paying what's required for that lump sum. It's not the same as, say, the weekly child support obligation. Not at all. So if the non-custodial parent has to pay $100 a week, and that employee is getting $1,000 lump sum payment, the answer is not. It's not, well, I got to take out $100. The rules for a lump sum are different and have to be complied with in these circumstances. Call New York State, as I'll give you the instructions as we go forward in the presentation. There are many different examples of lump sum payments. This list is by no means exhaustive, but the ones that come to mind and ones that employers most frequently ask on. Lump sum payments include bonuses, retirement incentives, 1099 income, commissions, workers' compensation, Social Security, severance payments, insurance settlements, personal injury settlements, stock options, dividends, and leave payouts. For any lump sum payment that's about to be paid out, the best practical way of doing this, of making sure everything goes right, is to contact the New York State Child Support at the email presented on the slide, or to call at the number presented on the slide. The child support representative will ask you information that you're going to see in subsequent slides and help you walk you through it and tell you how much has to be garnished based on the type of lump sum payment, and whether or not CCP, and CCPA limitations applying or not applying. So this email and phone number at the bottom of this slide and shown to you in subsequent slides is the holy grail to lump sum payments and figuring out how to do it correctly. The lump sum reporting process: first, contact the support distribution unit to determine whether or not there is past due still owed by that non-custodial parent and how much. If there's no past due child support due, the SDU will tell you this, and 100% of that lump sum goes to the non-custodial parent. Suppose there is past due child support. The next question is the payment for personal services. If it does go to personal services, then the CCPA limitations do apply, and that 50 to 55% calculation will mandate how much child support can garnish from that lump sum, right? So if the bonus is $1,000, then child support would garnish 50 or 55% of that amount, depending on whether or not what the arrears amount are. If there are no if it's not for personal services, like a dividend or something like that, then there are no CCPA limitations that will be calculated, and child support can garnish 100% of that lump sum up to the amount of arrears that are owed by that non-custodial parent employee. Again, I mentioned CCPA limitations, personal service versus non-personal service. If the payment for that lump sum is a commission, if it's a severance payment, if it's a leave payout, if it's a bonus, those CCPA limitations of 50 to 55% would apply. If the payment is a dividend, an interest payment, a benefit, well, then the CCPA limitations would not apply. And again, 100% of the garnishment is on the table. How to do this? You're not sure? Contact the New York State Child Support. Give the company name, address, phone number, email address, the information, on the on how much the lump sum is, the expected date. The New York State Distribution Hotline will help you determine the right amount that needs to be paid. Independent contractors. Employers are responsible for garnishing for independent contractors just as if they are employees. And if you receive an IWO from a non-employee, you must make the payments and withhold those payments like it's an employee. These perhaps are one of the biggest questions that I've seen of employers, of organizations that retain independent contractors. Independent contractors' salaries, lump sum payments must be garnished. One of the last things we should talk about today is the EWO, the electronic filing of income withholding orders. Again, it's free, it's effective, it's cost saving on how and an efficient way to electronically exchange IWO information without doing paperwork, without it getting lost in the mail, without it going to the wrong address, without any of that follow-up employer non-compliance information or phone calls, because you're getting the IWO electronically sent to you. It's a great way of doing this. It's a great way to go paperless. There are two types of options here that, and for your business. One is the no programming option for those organizations that have limited technology resources. The other is a system to system, which is fully automated and which updates employee information. Very helpful to us, very, very helpful to you to organize this IWO process. I've included in the presentation a contact email for you to ask questions. I've included in this presentation the website where you could learn more about this EWO procedure. Again, we're here to answer all your questions. They at that contact email address are there to answer your questions, because we would encourage the EWO. It's important, it works well, and please, like I said, if you after this presentation, go on the website, contact in the email, learn more about it, because anything done electronically, such as this, is a win-win for you and for us.
This is Angela Baraka-Levine. It's time to take another poll. Poll number 3. When an employee has multiple IWOs, the employer's top priority is to withhold current support for all orders to the greatest extent possible. True or false? That statement is true. Back to the video.
As with any thorough presentation, we want to end the session with giving you contact information if you have any questions. Keep in mind that many of the topics, IWO, MEDX, the calculators, that were discussed in this presentation and every other presentation today are reinforced on the New York State and New York City child support websites for your viewing pleasure. And of course, both New York State and New York City customer services stand ready to answer any of your future questions, and again, to foster this partnership and the work to the benefit of both your organizations and ours. Thank you very much for your time today. It was very much appreciated.